Today we are going to understand about Section 192 of the New Companies Act 2013. And this section is not only from a New Companies Act, it's actually a new section which was not there until now in the Companies Act 1956. The section deals with the restrictions on non-cash transactions involving directors. Okay, so there are three distinct things over here. One is the director. So the question comes in, which director? Second is a non-cash transaction. So non-cash, we understand what is the transaction which we are referring here. And if these kind of transaction happens, what is the consequences? So let's understand them one by one. So the first thing is restrictions on non-cash transaction involving directors. Now when we talk about directors, what we mean here is not only the directors, but also any person who is connected with him. With him means with such director. So it could be either a director himself or it could be any person connected with him. And what we mean is that the director should be a director of whom? So let's say if we are talking about a company A in this case, then this person can be anyone who could be a director of the company itself, of the holding company of the company, which is this particular thing. It could be a director of the subsidiary company, or it could be a director of an associate company. So if you are a person who is a director in either the company itself or the holding company or the subsidiary company or the associate company, and you enter into a non-cash transaction, and this non-cash transaction can be twofold. It could be one where the director is actually selling some asset, okay, or it could be the one where the director is buying the asset, which effectively means that if you look at it from a company perspective, the company could be either purchasing an asset from the director or transferring the asset to a director. And what do you mean by director? It could be a director of the company itself, of the holding company, of the subsidiary company, or of the associate company. What constitute each one of them, you'll have to see the specific direction. In case this happens, then these provisions are attracted. And once these provisions are attracted, then what happens? Let us go through that in the next slide. In such a case, if this transaction is taking place, when can such a transaction be entered into? Or what are the consequences if it is not entered into in accordance with these guidelines? So the first condition is that the prior, it's not post facto, it's a prior approval. So before you enter into such a kind of a transaction, there has to be a prior approval in general meeting of the company. So the company in its general meeting has to approve such a transaction which is in the nature of a non-cash transaction with the directors. The section additionally says that the prior approval in the general meeting of both the companies, which both company, the company itself and its holding company, where the director or connected person is a director of its holding company. So what does this mean? Let's go back and look at that particular picture. In this case, let's say for example, this director or connected person is a director of the holding company. Okay, and the company, which is company A in our example, enters into a transaction. Okay, so this company enters into a transaction with this director, and this director, by the way, happens to be a director in the holding company. Okay, it could be director or person connected with him. In that case, you need to obtain the prior approval not only of company A but also of the holding company, and both these approvals have to come in the general meeting of the two companies. So once you are entering into such a transaction, we know that we require the approval of the general meeting. But when you send the notice for such a thing, okay, the notice for approval in either cases, which means that the notice of approval in either or both the above cases, either means what? It is in case where the director is only a director of the whole main company, or it is a director in both the cases, shall include the details of the arrangement and the value of the assets as calculated by the registered valuer. So before this is passed, before this is considered in the general meeting, what is necessary is that the details of the asset, the value of the asset, the nature of arrangement has to be submitted to the company, and this valuation has to be carried out by a registered value. It cannot be by someone else. But what happens if any transactions is entered into in contravention of these provision? If that happens, transaction in contravention of the above provision, which means that these approvals are not obtained, shall be voidable at the option of the company. Okay, the company has a right to treat these transactions as void, having null effect, but not in the following two cases, whereas where the company is compensated for loss by any other person. So this company is compensated for any kind of a loss. So let's say if the asset was worth 100, the company sold it for 80, it had a loss of 20. And if this 20 is compensated to the company, then the company cannot come back and say that I want to make this transaction void. And restitution of the subject matter is not possible. And second is a right acquired for value and without notice of contravention of these provisions. So let's say there's a person who's connected to a director who entered into a transaction with the company and he was not aware of these provisions, right? And he actually bought the asset for 100. In that case, the transaction cannot be considered as voidable at the instance of the company because he has acquired the rights for value and he's not aware of the contravention of these provisions. I hope you had a good time understanding this. Thank you for being with us today.